I'm going to go through a pretty ambitious agenda in terms of medical marijuana. I'm going to talk about what marijuana is, uh, where it's come from legislatively, to where it presently is, where it's going, how this may affect your policies at the workplace. I'll tell everybody at the outset, I don't know everything regarding marijuana or medical marijuana. The subject matter is vast, and the medical marijuana control program, which governs Ohio, is also a very, very big law. I'm not particularly interested in the criminality here in Ohio for employers. I don't think that's as much of a concern as what you can and can't do with your workforce and how the marijuana medicine may affect your employees. So that's where my focus will be. And with that, we'll get started. So I've given speeches on medical marijuana now since probably 2015 when we had the first ballot issue to make a constitutional amendment to our Ohio Constitution. And the interesting thing is that people always have a misconception about this law. No matter how often they read about it or it's presented to them, they always think of this law as some sort of smoking law. So as you can see depicted here on the screen, we've got, Cheech and Chong smoking a big blunt, this giant marijuana cigarette in History of the World, if anybody remembers that movie, circa 1981, 1982, and Teddy Bear from the movie Ted smoking a bong. That's not going to happen in Ohio legally. People may smoke marijuana, but it's considered illegal. This is a no smoking law. Okay, I cannot emphasize that enough. If you get nothing out of this presentation today, please understand that smoking marijuana is prohibited under the Ohio Medical Marijuana Control Program. Okay, there are a number of different methods that medical marijuana can be delivered. And by delivery methods, I'm not talking about Amazon sending it to your front door. What I'm talking about is how the marijuana is delivered into the body, which then in turn has an effect on, or maybe does not have as much of an effect on somebody's brain and functioning. Okay, so under this law, the first, well, it's not the first, but one of the methods of delivery is a patch, which is a dermatomal patch. The marijuana comes in through the skin. A second method is vaping, which I think a lot of people are familiar with. There are a lot of commercials on vaping. You may wonder, well, what's the difference between vaping and smoking? Why is smoking disallowed, but vaping is not? Vaping is a process where the product is heated to a point just short of combustion. Once you get to the point of combustion, then you are smoking. And I've always made the reasonable assumption that because this is a medical marijuana law and it's a very strict law here in Ohio, that there is a concern over whether smoking the product can result in some sort of carcinogenic effect on the body. There are a number of doctors who believe that smoking marijuana, just like smoking cigarettes, can lead to cancer. So because this is a medical law that we have, I imagine that the medical doctors who were consulted in the development of the program didn't want to go there. And so they decided that vaping would be okay. The other thing is, in terms of vaping the product as opposed to smoking it, I think you can also manage the psychogenic effect because I believe that the THC, which we'll get into a little bit later, is a little bit modified compared to when you are smoking it from a marijuana cigarette. Another method is edibles. We're all familiar with this. Under the Medical Marijuana Control Program, the edibles cannot be in a form that would be attractive to children. So I would imagine that we're not going to see any gummy butt ups with Fred Flintstone or SpongeBob or whoever your favorite cartoon character is, because that would be in a form that is attractive to children, and that would be harmful to their health. Oils is another way of getting marijuana into your system. Tinctures, little droplets, which you can place underneath your tongue to deliver it orally to the system. And then the plant material itself. And so right now we are dealing with the plant material only. And as I'll get into that a little bit later, the law is pretty new, so all the products are not available. But these are all the methods that it can be delivered. Now, why is this important to you? The way marijuana gets into your system will have different effects because the body metabolizes the marijuana differently as it is ingested in different ways or consumed by the body in different ways. So smoking a marijuana cigarette is the fastest way to get a high. Vaping, probably almost as fast. The patches take a while to get into your system, as would an edible, because an edible has to travel through the GI tract. Okay, so understanding the method of delivery is important to knowing whether or not your employee or people who are using medical marijuana may be at an intoxicated state faster than somebody else if they have recent use of the medical marijuana. One other form that currently is not approved but has been petitioned to be approved is nasal sprays. And I don't have any current information as far as how quickly that enters the system, but I'd imagine it's someplace between 30 minutes and 1 hour, just based on the other methods of delivery. So a good starting place in this discussion, and it may seem sort of rudimentary, is what is medical marijuana and what is marijuana? Because there's a difference between medical marijuana in the legal sense, there's a difference between marijuana in the legal sense, and then marijuana as we think we know it as general consumers. So as a practical matter, marijuana is a plant. But let's talk about it in terms of cannabis, because cannabis is the plant. And there are various forms of cannabis. The strain that we've come to know as marijuana is a particular strain of the family of plants known as cannabis. And for centuries, essentially, probably 2 millennia, man has used cannabis in either the industrial setting, in the medicinal setting, or recreationally. Okay, this goes back a long way in the history of mankind, and so it's not new. When it became something that was regarded with a stigma or was regarded as a drug or dangerous, those concepts really came about at the turn of the century. And people up until that time were free to use the drug without any regulation whatsoever. So understanding the regulatory history of marijuana, I think, is important when you're thinking about the medical marijuana control program and other medical marijuana laws or other marijuana laws, because you have to understand how we got to the place where we currently are. Up until around the turn of the century, as I said, there really were no regulations, but at the turn of the century, there seemed to be a focus in this country on the use of drugs, primarily opium, and all substances that would lead to a form of intoxication or an altered state were scrutinized by the medical community and legislators alike. You know that in the early 1900s, there was an alcohol prohibition. Marijuana at that point had not been studied. It was long before any research had been done on it, but doctors were prescribing it to their patients because of the effects that it can have on pain and other health conditions. People were using it recreationally. There are accounts of Mexicans using marijuana recreationally after a hard work day to relax. Okay? And so in the first probably 30, 35 years of the 20th century, marijuana was being used in a number of different ways, and also a product known as hemp was being used. And there really wasn't much of a distinction in people's minds between hemp and marijuana. They're all from a cannabis plant. So around 1935, some senators decided that they wanted to wrap their arms around marijuana. You had a number of state laws that regulated marijuana. I wouldn't go so far as to say that marijuana was banned anywhere, but they regulated its use. Marijuana was considered a poison. So anything that altered your mind or your state of being was considered a poison. So marijuana was considered a poison. And a particular senator decided that he wanted to regulate marijuana under what's known as the Marijuana Tax Act. He sent out some propaganda that talked about marijuana's ill effects on the body, how it led to deviant sexual conduct, and essentially made people who smoked it lazy. And so there was a growing negative stigma associated with the use of marijuana. Curiously, though, there was also some competition among industry leaders on the use of the hemp product. Hemp can be used a number of different ways, and it can be used to create paper products, among other things. And so there were leaders in the paper industry that did not like the idea of other industry leaders using hemp to cut into the profits of the paper industry. And so the whole idea of the cannabis plant and its effects both on industry and on people's health and well-being became an issue. And so Congress passed the Marijuana Tax Act of 1937. The medical community somewhat objected because they thought that regulating marijuana under that law would be inappropriate. Medical doctors at that time really didn't know the difference between cannabis and marijuana. They didn't know they were the same thing in some respects, and they didn't get to weigh in on the debate. But needless to say, the law went into effect, and it stayed in effect basically until 1969, when the Supreme Court overturned the Marijuana Tax Act in a case called Leary versus the United States of America. And the Supreme Court overturned it on the grounds that it was unconstitutional. That led to the Controlled Substances Act of 1970, which was part of Richard Nixon's war on crime. Nixon had sort of an agenda at the time. If you'll recall, we were fighting the Vietnam War. There was a lot of opposition to the war. Nixon did not like that opposition, and he wanted to put his foot down. And so legal scholars have stated that, in part, he established this law to essentially squash the war opposition, which was primarily hippies from the 60s and people who tended to smoke marijuana and use marijuana. It was also heavily used in a number of minority communities and considered to be something that people used that basically were derelict. So Nixon came down hard on it. And when he did, he didn't just regulate cannabis, marijuana. He regulated everything. So when you look at the Controlled Substances Act, it regulates cannabis, which includes not only marijuana, but also hemp. So what's the definition of marijuana legally? You know what it is when you smell it. You might know what it is when you see the plant, but that's relatively meaningless. It's only important in the context of Ohio law in terms of how it's defined by the statute. So the statute defines marijuana as all parts of the plant of the genus cannabis, whether growing or not, the seeds of a plant of that type, et cetera, et cetera, et cetera. That's the definition of marijuana, which was on the books before the medical marijuana law went into effect. So, that being marijuana, what would medical marijuana be? Well, first thing is, why do we even care about marijuana? Why do we care? Why is there a law on this? Why are we trying to regulate it? Well, marijuana is a hallucinogen. And if the GIF image on the screen is causing you discomfort, look away. But essentially, hallucinogens alter your brain. And they cause an altered state, which might lead to a loss of coordination, a lack of judgment. Marijuana is just like, to some extent, LSD or ecstasy, drugs like that. It's not as addictive as, let's say, opium. In fact, I'd say most studies find that marijuana really isn't addictive at all. It's addictive in the sense that people develop a psychological dependency on it, which is consistent with other hallucinogenic drugs. So it's the kind of drug that can cause you to lose balance, lose comprehension and sight and sound, things of that nature, which is a general rule, if you're using that in an industrial setting, could be very dangerous. So that's why we care about marijuana. It is a mind-altering kind of a substance. Whether you want to call it a drug or not is up to you. Under the medical marijuana control program, medical marijuana is what's being regulated because marijuana to date is still not legal in a recreational sense. So medical marijuana is anything that's cultivated, processed, dispensed, tested, possessed, or used for a medical purpose. So we have this very broad program now that addresses all of that. Essentially, it's getting a marijuana product ready to be sold to a consumer to address some sort of health issue. So you've got the anatomy of the plant. So you've got the leaves from the species cannabis. In a cannabis plant, especially if we're talking about the cannabis sativa, which is the marijuana plant, there are over 100 chemical compounds. Not all of these have effects on the brain's receptors, but many of them can. The ones that we're most concerned about in the marijuana debate would be two cannabinoids. Okay, so all these chemical compounds are known as cannabinoids. The two we're concerned with are tetrahydrocannabinol, also known as THC, a lot easier to say, and cannabidiol, CBD. These are the two primary components that we are most often concerned about. And you can use essentially all parts of the plant to treat diseases and symptoms of conditions. So what's the difference between CBD and THC? There is an important distinction which is relevant to regulating cannabis under the Ohio law. THC is the component in marijuana that causes that psychoactive effect that I was talking about. If you think back to the slide that was up there with the flashing GIF, it causes you to get high. And that's what we think of when we think of people smoking marijuana as getting high. It's the THC content that does that. When you're smoking marijuana, there's a very, very high THC content. And taking it in through the lungs is a very fast way to get it into the body. But even with THC and the THC cannabinoid itself has effects on the human body. In addition to the mind-altering effect, it's been shown to reduce pain and nausea, So if you are a cancer patient who might be undergoing chemotherapy, which is going to lead to nausea, a THC product might be something that a doctor would recommend for you to help abate the nausea. THC affects inflammation. It helps to control muscle problems, so people with like epileptic kind of symptoms might benefit from it. CBD is not all that different. The CBD also is effective for pain. It's also effective for seizure kind of activity, inflammation. Generally with pain, there is inflammation. But the biggest difference between CBD and THC is that CBD does not contain any THC. There's no mind-altering component of CBD. So if you extract from the marijuana plant CBD alone, then it's unlikely that you would use that product and have to worry about your faculties. So as I said, the law we have is a medical marijuana law. So don't lose sight of that. It is not a marijuana law, it's a medical marijuana law. Ohio's law is probably one of the most restrictive in the country, okay? It regulates the amount of THC that can be dispensed by a dispensary. It regulates the dosing that you can use. It regulates where you can use the product, where you cannot, what you can operate, what you cannot, whether or not an employer can fire you with knowledge that you're using medical marijuana. It's a very employer-friendly law. It's a very restrictive law. And so we are in a jurisdiction, if you are someone that wants to know that there are protections under this law and people aren't going to be running around the plant smoking marijuana joints, then this law would suit you just fine. In terms of regulating the THC in the statute itself, okay, the statute provides that you cannot have more than 35% of the plant material comprised of THC. Okay, that's before it gets to the processing stage in which they are going to take that plant and then turn it into something that can be sold on the open market to medical marijuana patients. No extract can be more than 75% THC. And then in terms of the dosing, because once it's ready to be packaged and sent out to a dispensary, it can have no more than 50 milligrams of THC. These numbers may be relatively meaningless to you. I mean, to me as a layperson too, I don't smoke or use marijuana, so I don't really know what that means. But according to my research, 50 milligrams of THC is a pretty high dose. Okay, now that is the max, so it can't be more than that. But THC up to 15 milligrams can start to have that psychogenic effect. As you go from 15% up to 50%, you're going to see incrementally more symptoms in terms of the psychogenesis that's associated with marijuana. But marijuana, like any other drug, requires a certain amount of tolerance. So depending on what the medical condition is, the doctor's not necessarily going to prescribe the maximum amount of THC milligrams for a patient. They may work their way up to that depending on how the patient responds to the treatment. But all of this will be clearly labeled on the packaging, just like any other drug or food that you might find. Think of the labeling on food packaging that shows you the number of calories and carbs and protein and all of that. The packaging for marijuana products are going to show you how much THC and how much CBD is in there, and what the recommended use would be. So everybody should know that this law went into effect back in September of 2016. People erroneously believed that the law was going to become operational in September of 2018. because a lot of people misread one of the pronouncements in the statute, which was the law should be operational within 2 years. The way that language was stated, though, it was more permissive language that said that the Board of Pharmacy will do everything within reason or everything possible to ensure that the law is operational by such date. That's lawyer talk for we're going to do our best to have it operational by that time. So it is operational now, though, and understanding what that means, we need to talk about the process of getting marijuana from seed to the point where it can be packaged and then dispensed to the public. First thing that happens is you got to plant it, right? So planting began for medical marijuana under our program back in September, October. And it takes a couple of months for a marijuana plant to grow to full maturity. After that takes place, then the crops are ready to be harvested. And that was back in late December. So the idea is it's going to start working its way into the marketplace sometime in January, which if people have been watching the news, understand that we have started to see sales of medical marijuana. The Medical Marijuana Control Program has issued some reports on how much revenue has come in from the sales of medical marijuana. But it was a process that took around 2 or 3 months to get started. At each stage of the process, there has to be lab testing. So they test it once it comes from the cultivator, and before it goes to the processor, it undergoes testing. After it leaves the processor and before it gets to the dispensary, it undergoes further testing. And then once it's at the dispensary and it gets packaged, then it's ready to go out to the public. So this product, as I said, rolled out in January, but because right now there are not a whole lot of cultivators, processors, and dispensaries in place, you're not going to see a whole lot of product. And because it took so long to get this product to roll out, because there's not a whole lot of processors yet in place, you're only going to see it in limited forms, which is why I said at this point, it's probably only being sold in the plant material. It hasn't really been dispensed as an edible or tincture yet. That's going to happen. The anticipation is that's going to happen by sometime a little bit later this spring. And so up to this point, a lot has gone into place for this program. After you have a law, the law tells you generally, what this law is intended to do. It says broad parameters, but it's the rules that underlie the law that establish basically the meat on the bone. And so the rules all went into place several months ago or about a year ago. That's already taken place. You've got rules for the Board of Pharmacy. You've got rules for the doctors, rules for patients and caregivers. You've got rules for the processors, for the dispensaries. Next thing you need to have are doctors to, quote unquote, prescribe it. But they don't call it prescribing it in Ohio. We call it having a certificate to recommend marijuana. As of today, because I don't have any other current information, there are almost 400 doctors around the state that have certificates to recommend. You'll find that the majority of these doctors with the certificate to recommend are in your metropolitan areas. So heavy concentrations in Cleveland, Columbus, Dayton, Toledo, Cincinnati. That's where you're going to find most of the doctors with a certificate to recommend. We need the processors and dispensaries and cultivators certified as well. Right now, there are only 6 dispensaries open, or at least there were as of about a week ago. So the more dispensaries that come online, the more processors that come online, you're going to see more widespread dissemination of medical marijuana products. And finally, the patient registries have been established. The patient registry is something that can happen online, but if you're a patient and you think you have a need for medical marijuana, you can't just go and register yourself. Okay, it's the doctors with the certificates to recommend that will register patients and caregivers for basically the activation of a registry card. So patients still are at the beck and call of their doctors, and there has to be a bona fide patient-physician relationship before anyone can receive a recommendation for medical marijuana. But right now, there are over 17,000 people that are registered. That number, of course, is going to continue to grow. So what's left to be done? Because we have a working program now. The patient registry has to fill out. You're going to continue to see the numbers grow, as I said. Reciprocity. A lot of people are very curious. What are we going to do with someone who lives in Michigan, for example? State that if you live here in the Toledo area, that's 5 miles from downtown. So are people who are getting medical marijuana or recreational marijuana in Michigan going to be able to come into Ohio and legally use that product? So reciprocity has to be established. And then we have to get a handle on adding qualifying conditions. Because as you know, under the statute, there are a number of qualifying conditions that were written right into the law 2 years ago. So as far as reciprocity is concerned, the law provides is that the Board of Pharmacy is going to make a good faith attempt to negotiate reciprocity agreements with other states. Okay? There's no requirement that we engage in these reciprocity agreements, but that is the goal of the medical marijuana program, is to do that. That requires two things. The eligibility requirements have to be substantially the same as they are here in Ohio, and the other states need to recognize the patient registry cards here in Ohio. It is a quid pro quo. As of today, there is no indication that the Board of Pharmacy has established a reciprocity agreement with any state. Okay? What you will find as you go from state to state is that marijuana laws are drastically different. And that's something you need to keep in mind, especially when you think about the cases that come out of different states. Each state regulates things in a different way. They provide different kind of rights. There are different qualifying conditions. There are a number of differences among the states. So just because something is legal in one state doesn't mean that Ohio is going to look at their law and say, bring all your patients here. Okay? Now, in terms of the qualifying conditions, these are all set out in the statute. We've been through this before for people who have been in on my webinars or at my seminars. A number of very serious health conditions. We looked at this list a couple of years ago. For some of us, there were conditions that stuck out, and we were wondering, well, it'd be nice to know what percentage of the patients are treating with medical marijuana that have, let's say, ALS or cancer or spinal cord disease or PTSD or seizure disorders. Because when you're thinking about the people that are in your workplace and use of medical marijuana, you have to be thinking, well, what's the likelihood that I could have somebody in my workforce that's actually going to be utilizing one of these products? Well, the Medical Marijuana Control Program is actually doing the research for us. And what you will find is that the conditions that sort of lead the way are intractable or chronic pain, post-traumatic stress disorder, and fibromyalgia. These are conditions that I would venture to say a lot of people that you know and a lot of people that are in your workforce probably suffer from. um, especially chronic pain and fibromyalgia, because fibromyalgia is fairly unexplainable. And with aging workforces, and once you get past the age of 30, it's well known that the body starts to slowly degenerate. That's what happens. Unfortunately, the discs between all of the bones start to deteriorate. You start to develop spurs and other signs of arthritis. It's just a function of getting older. And so by the time people are middle-aged, they've got some pain that they've got to manage. If they had a workplace injury or an injury elsewhere, then they might have a chronic pain syndrome or issue. And, up to 17,000 people who are registered under this program, you've got about, looks like 14,000 of the 17,000 that could be people that would be in your workforce because of how the numbers bear out. Cancer is number 4 on the list, but under number 5 would be spinal cord disease or injury. So then we're right back in the workplace because people get hurt. So these are interesting statistics, something to be aware of. Now, in terms of adding qualifying conditions, it's not as simple as simply saying, hey, I want to add, carpal tunnel syndrome. There's got to be information from experts in the field, specialize in that condition, that have some knowledge about whether or not medical marijuana is an effective use for that particular condition. This has got to be submitted to the program. There's a requirement of scientific peer-reviewed evidence, which incidentally is difficult to come by, because when the Controlled Substances Act went into effect back in 1970, one of the things that the Act did was it severely restricted the ability for people to research marijuana, because under the Controlled Substances Act, there is no there's no use of marijuana, no logical use for it. The Controlled Substances Act finds that marijuana shouldn't be used under any circumstances. So the research on this is very limited. But still, if you want a qualifying condition added, you've got to come up with something. The doctor has to attest basically that this is the last chance. Nothing else is going to work. This is a last resort sort of treatment because everything else has failed. And then there need to be additional letters from physicians that would support the use of medical marijuana. This is a pretty high hurdle to jump. And so back in the early part of the winter, the program received 110 petitions to add qualifying conditions. Only 9 petitions have moved forward. So that means 101 were rejected for one reason or another. You can look at the slide and you can see the reasons. But interestingly, the conditions that are moving forward for further review, and which will be decided on sometime in June of this year, are opioid use disorder, chronic anxiety and general anxiety. Both conditions are very similar to PTSD, and depression, which is another mental health condition, which a good portion of the general population suffers from. So we talked a little bit about CBD and THC, and I talked about hemp being a cannabis plant as well, or part of that family. So a question came up back in October when I was doing this seminar for a safety workshop, is CBD from hemp going to be regulated by the Medical Marijuana Control Program? Because if any of you have used the CBD product up until this law became operational, you're able to get it right on the shelves of, pretty much any store. I mean, the CBD products were out there. However, whether or not CBD from hemp is regulated under the Medical Marijuana Control Program really depends on what the definition of marijuana is under the law. There are some differences, though, between hemp and marijuana that you need to think about. When the Tax Reform Act, the Marijuana Tax Act, went into effect in 1937, it made no distinction between hemp and marijuana. Remember, they were also trying to restrict the sale of hemp because it impacted the paper industry. When Nixon signed off on the Controlled Substances Act, again, it made no distinction between hemp and marijuana. But there's a difference. And people that are in the know will tell you there's a big difference between hemp and marijuana. So what are those differences? Well, marijuana, as we know, has got that psychoactive THC. It's used medically and recreationally. The plant actually looks a little bit different. It's a short, fat bush. And it does require certain growing conditions. Usually a warmer climate is better for marijuana. You can't grow it everywhere. Hemp, on the other hand, is generally used for industrial purposes. I was told by Carrie that Ford actually made cars from hemp back in the 1940s. It's a very, one car. It's a very durable product. I mean, you can use it for, I think there are dermatological products, skin products that can be made from hemp. Rope is something that we commonly think of. But CBD products that come from hemp are what people are most interested in right now because of the marijuana debate. The only thing that marijuana and hemp have in common is that they're from the same family of cannabis. And so that leads us right back to the definition of marijuana under Ohio law. It's all parts of the plant of the genus cannabis. That's why hemp is included. Hemp is part of that family. And so what we've seen recently in the news, if you've been paying attention, is retailers of CBD products basically had to pull these products off the shelves because CBD can only be sold legally through a medical marijuana dispensary. And right now, dispensaries aren't set up to sell those kind of products because they have to go through the entire process. They have to be cultivated according to the Medical Marijuana Control Program's rules. They've got to be processed under the rules, and then they have to be tested under the rules, and then they have to be dispensed under the rules. And so in that regard, CBD is not permissible under the Medical Marijuana Control Program. And if you go to the MMCP's website, they have a fact sheet that'll tell you exactly that. Interestingly, though, 2 months ago, in December, President Trump signed the Agricultural Improvement Act of 2018, which legalized hemp. The definition of marijuana under the Ohio statute almost mimics exactly the definition of marijuana under the Controlled Substances Act. And so when President Trump signed that bill and it went into law, legalizing hemp, hemp was removed from the definition of marijuana under the Controlled Substances Act. It legalizes industrial hemp with less than 0.3% THC, which is basically negligible. But still, hemp is not legal in every state. Very recently, a truck driver, I can't remember which state he left. He was driving through Idaho. He had a cargo full of 7,000 pounds of hemp. He got stopped. The police looked in the truck. They thought that it was marijuana. And, as a practical matter, I guess you could say it's part of the plant, the genus, the family. And they seized it because in Idaho, hemp is not legal. So I want to show you a map. This is my map section right now. This map shows you all the states in the country that have got laws that are related to hemp, that regulate it in some way or allow its its use or testing in some way. And what sticks out on the map, obviously, is that Ohio is not one of those states. It does not legalize hemp. However, this morning, I was eating breakfast, getting ready to come into work, and I saw on the news that as of yesterday, there is a bill that got introduced to legalize hemp in Ohio. So Ohio is trending with, I think, the norms countrywide. People are more and more comfortable with the use of hemp products and drawing a distinction between hemp and marijuana, as well as marijuana in general. So under this new Ohio law, if it becomes law, it would redefine hemp, just like the Controlled Substances Act did. So you wouldn't have it prohibited under the definition of marijuana. It wouldn't come under the Board of Pharmacy's jurisdiction, which currently has jurisdiction over medical marijuana in Ohio. It would go under the Department of Agriculture. And the idea is that legalization of hemp and hemp products like CBD would help the economy. Farmers right now are struggling a little bit. The hope is that this will create a new revenue stream, enabling farmers to start harvesting hemp and using hemp and selling hemp, moving it along in the process to be sold in the hemp product industry. So that's the goal of this new bill, and we'll see whether or not it comes into law. But over the last few years, attitudes have changed. It's not the 1970s anymore. There's no longer the stigma attached with marijuana and hemp and all of those products. The country's changing, and it changes very rapidly. As I said, this bill got introduced yesterday. I was working on my presentation. I didn't even know about it. I found out about it over breakfast. This map is a map that I used back when I first made this presentation in 2015. And it shows you that about probably half the states maybe had some medical marijuana laws on the books. Probably about 5, including, I think it includes the District of Columbia, permitted recreational marijuana. That was only 4 years ago, more like 3 years ago. This is the map from last year, which shows how marijuana has expanded throughout the country. The line segments are states that have or permit CBD oil. Okay, so there's a recognition that that's different than marijuana. And now this is what we're looking at today. There are, 23 states with medical marijuana, 33 total, including recreational marijuana. This is a big part of the country right now. The growing trend is for legalization of marijuana countrywide. And so these are two important charts because they show you where public opinion has gone since the Controlled Substances Act became law, since 1969, all right? Back in 69, 84% of people thought that marijuana should be illegal. Only 12% thought it should be legal. In 50 years, 49 years, the tables have turned. Now 62% of people think that marijuana should be legal, and only 34% find that it should be illegal. The chart on the right-hand side is even more telling because it breaks it down according to age groups. Millennials, who had nothing to do with the hippie movement in the 70s. They probably don't even know who Richard Nixon is without looking in a history book. They probably don't think of marijuana as having the stigma that older people do. But even the Generation X and baby boomers, people who were alive during the period of time in which this country saw marijuana very negatively, have started changing their views because I think there's a recognition that marijuana does have some beneficial health effects. I mean, this graph doesn't say whether or not these subgroups believe in the use of recreational marijuana. It just says marijuana. But having looked at other polls and studies, a very significant number, a majority of the people in the country believe that at the very least medical marijuana should be legal because of its health benefits. And significantly, if you look at the chart on the right, even people born in the silent generation, as they call it, between 1925 and 1945, you see a significant increase from 15% to 39%, probably because they're experiencing chronic pain, which happens as you get older, and they've learned about the benefits of medical marijuana either through research on the internet, which is available to all of us, or through their doctors. So as we continue to progress, we have a new House of Representatives now, which seems to be marijuana friendly, and a bill got introduced called the Marijuana Revenue and Regulation Act, which is one of 3 bills which is aimed at legalizing and regulating marijuana. We'll see where that ends up. Dangers, its effect on the body, people's viewpoints on marijuana. How is that going to affect what you're doing at the workplace? Well, we surveyed people a while back, and overwhelmingly, people have the same kind of concerns in the workplace. How is this going to affect my current drug policy, and do I have to accommodate medical marijuana? Those were the 2 big ones. To a lesser extent, employers want to know, can they terminate people, or what's this going to mean in terms of drug screens? There's a common thread pretty much in all drug and alcohol policies that employers have. I think all employers are concerned about intoxication at the workplace, whether it's alcohol, whether it's opioid abuse, marijuana, LSD, you pick something. Intoxication is big on that list because you don't want your workers running around work spaced out. And generally speaking, most employers are only concerned with regulating what happens at their place of work. Most employers aren't policing their employees when they're on their own time. Of course, people have to be fit to work. If they're high or their body's affected because of a particular drug, they're not going to be able to be productive. That's no good because companies are in business to make money. And employers generally like to see workplaces that are free of illegal activity. So even, to the extent that your policies address legal drugs, there is an interest by employers not having the illegal drug element as a part of their workplace. So these are the common threads. Job performance is another one. Testing, whether or not the company's in compliance with state and federal laws. So when you craft your policies, why do you have them? What comes out of those common threads? Safety, productivity, the morale of your workforce. What kind of message do you want to send people? And are you endorsing illegality at your workplace? This is usually what you're looking for when you're crafting your drug and alcohol policy. Okay. Messaging and morale are very important, and they cut both ways. Consider the fact that there is a growing trend toward the acceptance of marijuana now, and your policies on marijuana are going to resonate in a certain way with your workforce. Okay, and you have to balance that against your need to have a safe workplace. So, do you need to change your policies? Well, the question is, well, why do you have it? If your policy is about safety, then you need to construct something that's going to address safety in the workplace. It may not be concerned with what's happening after work. Do you want to have a blanket zero tolerance policy? I know employers that ban smoking. They're in the healthcare business. They ban smoking 24/7, 365 because that is the brand that they're trying to maintain. So is that a goal of yours? Are you concerned about use only at work? What are you willing to tolerate? There's some companies that look at really only using the drug policy for safety positions. If you have a workforce that's white collar only, you have to consider how important is it to you to prohibit the use of medical marijuana. It may still be important because even people that are working in an office setting can get hurt, and also their productivity may be affected if they're a little bit high. So you want to look at, why am I doing this? What are the benefits to my workforce? Because as an employer, you also need to be concerned with morale. And if people feel like they can't get treatment for legitimate health concerns and medical marijuana is the path to resolving their health concerns, you might lose employees. So it's hard to give advice without looking at somebody's policy, what may or may need to be tinkered. You may not need to change any of your policies, but what you need to be aware of are these kinds of concerns, these kinds of things that you have to balance. And if you have a question about changing your policy, then you need to get in contact with a lawyer who can look at it and help you craft a policy that's consistent with your goals. That's the primary issue. What are you trying to accomplish? Do you want to be a police officer and police your workforce at all hours of the day? Are you concerned with what they're doing at work? I'm going to zip through the rest of these slides because I see we're up on the hour. This was an ambitious agenda, but bear in mind also, bigger crisis than marijuana is opioids. I think everyone can agree on that because opioids are dangerous. They kill people. Marijuana has never been known to kill anybody unless you have somebody that's, driving under the influence and they drive into another person, or maybe they drive into a wall and kill themselves that way. But an addiction or dependency on marijuana is not going to lead to death. Opioids are serious. This image here was from a little snippet on CNN about how marijuana is now being used as an alternative to opioids to control pain and some other health effects that opioids would be used for. And so that's something that you also have to consider. I'd venture to say that most employers freely allow their employees to medicate themselves with opioids, and they restrict them coming into work under the influence of an opioid because it could be dangerous. Marijuana probably should be considered in a similar fashion. So we're coming up on the last few slides. Just a couple things on drug testing. Most employers are going to test in the pre-hiring phase and or right after a work accident. Those policies really don't need to change. The problem with marijuana, though, is so much of the workforce uses marijuana recreationally, okay? And that's not under the program. But so many people use marijuana in their free time that a lot of employers are opting not to drug test before people come to work for them because they're having a hard time finding people to work. That's a consideration you need to think about. But the other thing is about marijuana using, like the DOT testing, there is no limit that you can say someone is at and they're intoxicated, like alcohol. We have a limit for alcohol. But for marijuana, typically the DOT standard, the confirmation number is, I think, 15 milligrams uh, of what is it, milliliters of under the GCML test. And I'm no scientist, so I can't even tell. It's like gas chromatography, something else. I don't know what it's called. A doctor would know that. People that do your drug test do. But needless to say, the standard is 15 milliliters. That's just a confirmation test. It tells you that it's in the system. It's not going to tell you whether or not somebody was intoxicated. And as you know, marijuana stays in your system. It can stay in your system for 30 days. The question for the employer is it having an intoxicating effect? So even if you have a policy that calls for automatic drug testing after the work injury, and you get your confirmation test back and it tells you how much marijuana was in the person's system, this doesn't mean that you can't draw the conclusion that they were intoxicated. I had a case. You have to look at everything on a case-by-case basis, but you're always going to want to look at the behavior. And I had a case in which an employee basically crushed his own foot in between two toe motors. Very odd, okay? And he didn't report this. He alleged that it happened at, let's say, 10 o'clock. He didn't report it until 10:40, until he comes into the office with his foot dripping of blood. So the employer did a post-accident drug test, and it found that his level of marijuana was 92 times the cutoff level. Well, I was able to get the doctor to look at that drug test and say, this person was in fact intoxicated. When you're 92 times the cutoff level, the marijuana is significantly in your body. And because it's such a significant number, the intoxicating effect was also substantial, which led to this guy's loss of good judgment, probably loss of his coordination, which ultimately caused his injury. And that came up in a workers' compensation case. And although we couldn't use the rebuttable presumption under the law, we were able to argue causation, and that this worker's injury was caused by the marijuana use and not caused by anything else at work. And we were able to prevail on that. So you can prove intoxication. The things you want to look for are the things you always look for. Evidence of intoxication. You know, do you have a reasonable cause to test somebody? Are they acting strangely? You know, this guy didn't even notice that his foot was bleeding. His coworkers had to tell him this. So it was an amazing, amazing story. I'm going to, again, go through this pretty quickly. Under the Medical Marijuana Control Program, you are able to fire people, refuse to hire them, discipline them, take any adverse action against them under the law, and you are not able to be sued by the employee. This is all written right into the statute. So Ohio is an at-will state, but beyond the fact that it's an at-will state, you have a law that specifically provides that employers have rights to do whatever they want to do with an employee that they find has marijuana in his or her system. Okay? Your hands are not tied. In fact, just the opposite. Another big question for employers is, do I have to accommodate medical marijuana? Because you're all familiar with accommodations under either the ADA or the state disability law. The medical marijuana law specifically provides that you are not required to accommodate the use of medical marijuana. This is written specifically in the law. So, regardless of what argument somebody might make about an accommodation, you have a law at your disposal which provides that you don't have to do that. And under the Americans with Disabilities Act, there is also a very strong argument that you do not have to accommodate because under the Act, people who are engaged in the illegal use of drugs are not protected. So you might say, well, it's not illegal because it's allowable in Ohio. Well, it is illegal under federal law. The little box to the right comes right out of the federal statute, says a qualified individual with a disability shall not include any employee or applicant who is currently engaging in the illegal use of drugs when the covered entity acts on the basis of such use. So the ADA also protects you. Very recently, I read an article in the State Bar Association's, one of its publications, and some lawyer wrote that he thought there was a loophole in Ohio law and that Ohio employers might have to accommodate employees for medical marijuana use, and he cited to this case that came out of Massachusetts. You have to be careful about what you read in various publications. He even convinced me for a second. I had forgotten what was written right in the law. The problem with reading cases from other states is that those cases are always very specific to the law in those states. And in that state, in that marijuana law, it provided that you could not take an adverse action against somebody that was using marijuana legally under the state law. Okay, very different analysis. Ohio stands by itself. Laws of other states are not going to have any persuasive value here unless they are coming from or analyzing laws that look just like ours or very similar to ours. So be skeptical of what you read. I was surprised it actually got published in the State Bar Association's publication because that information is clearly misleading. There is no obligation to accommodate anybody. Just a couple things on workers' comp. The law hasn't changed as far as medical marijuana is concerned. The law was amended to include it, but basically there's still a rebuttable presumption of intoxication when somebody has got medical marijuana in their system. If you know anything about the workers' compensation law, the rebuttable presumption does not protect you entirely, it just shifts the burden of proof. And you do have to follow the prescriptions of the law regarding the posting of the drug test. That's where most employers fail because they have automatic drug testing. They're not testing based on reasonable cause. But as I stated earlier, when I was talking about that situation involving the fork truck, you can always argue causation. Causation is always available to you if you can get the evidence to support it. And that's where a doctor comes in place. If you do have the drug test, make sure that the doctor tests it or takes a look at it and gives you an opinion on whether or not the person could be intoxicated. The Bureau of Workers' Compensation is not recognizing medical marijuana. They basically follow the feds. And so because it's not FDA approved, it's not on the Bureau's dispensary, they're not going to reimburse for any medical marijuana use. It's not on their formulary. So you have no worries there. If you're a self-insured employer, you basically step into the shoes of the Bureau. You follow what they do. So if the Bureau is not reimbursing for it, you shouldn't be reimbursing for it. This is one of the last slides. People ask me about the Michigan recreational marijuana law, which just went into effect back in December. Under Michigan law now, in addition to their medical marijuana law, you can smoke marijuana, you can grow it yourself if you're over the age of 21. And so that's basically decriminalizes it to the extent that people can freely use the product even without a prescription or without some recommendation. Question is, how does this affect Ohio? If you've been listening throughout most of this presentation, you should know the answer. It doesn't, okay? Ohio's law is Ohio's law. If someone is using or smoking marijuana in Ohio, they are not protected under the Medical Marijuana Control Program, period. Doesn't matter what's happening in Michigan. That's in Michigan. But you should also know that under that Michigan law, curiously, the same kind of prohibitions or the same kind of rights that employers have in Ohio and that employers in Michigan have with respect to firing, discipline, accommodations, those rights are still available even under the recreational marijuana law. So there is no obligation on a Michigan employer to accommodate somebody that smokes marijuana recreationally. A Michigan employer can terminate somebody if they find that they are under the influence of marijuana. People that smoke marijuana recreationally are not allowed to do it in any public space. They can't do it at your place of employment. You can't drive under the influence of marijuana. So what that law does is it basically frees people up to smoke marijuana at home and in certain designated places. And they're not going to be arrested for doing it. But employers still have the right to protect their workforce and protect whatever moral code that company wants to live by, just as they did before that law went into effect. So hopefully that answers the question for people on the Michigan marijuana law and what effect it'll have here. The answer is none. We do have a law. It's the Medical Marijuana Control Program.
I always caution people, this is not necessarily the final word on marijuana in Ohio. Presently, there is a proposed issue
which might go on the November ballot here in Ohio to amend our Constitution to allow recreational marijuana. It's called the Marijuana Rights and Regulations issue. And it got certified by the ballot board back in the early summer or late spring of last year. So at this point, I don't know if they have all the signatures that they need in order for this to go on the ballot. I have no opinion on whether or not there's a chance that this thing is going to survive a vote. Anytime you're talking about amending the Constitution, that's risky business because constitutions are supposed to be held a little bit differently, and you only amend constitutions on very important issues. The issue of marijuana is probably one that should go before the General Assembly or the legislature. But needless to say, this issue is it could be on the ballot in November. And if you're wondering, what would be the fallout? Let's say the voters approve it. How would that affect you in the workplace? Well, this law, sort of like the law that just came into effect in Michigan, still affords you the same rights that you have to discipline, to not accommodate, to fire, to not hire, to not allow it in your workplace, to not allow people to drive it. All those rights are written right into the ballot issue. Okay? So an employer is not going to lose those rights. This proposed law or constitutional amendment would do the same thing that's happening in Michigan, which is basically give people the right to use it in their homes in certain designated places. Of course, if people are legally using marijuana, you might think, well, marijuana is going to increase now in Ohio. But, the reality is studies show in places like Colorado that legalization of marijuana really has not increased marijuana use. So I think that's more of a Chicken Little situation. The sky is falling. I don't think the studies bear that out. So I think it would be business as usual for you. Go about doing things the way you have been doing it. Understand that you still have all the rights, or you would still have all the rights that you currently have under the Medical Marijuana Control Program. Just a couple final thoughts. I kind of talked about case law. Be very, careful reading cases about other states and marijuana. I've heard lawyers in seminars say there's no case in which an employer was told they couldn't fire somebody for using medical marijuana, and then of course this case comes out in Massachusetts. That's not how case law works, and every law is different. So just be wary of that. It's interesting to see that the feds now have a bill that the House is proposed a bill that's going to legalize marijuana, because there are problems with the tension between the federal law and state laws. Here, for example, medical marijuana is legal, but if you're a caregiver and you have a card to provide medical marijuana to a patient, you also happen to have a concealed carry permit, you wouldn't be able to carry that medical marijuana legally because the concealed carry laws prohibit marijuana under the federal law. So you wouldn't be able to do that. There's some long-term care facilities that were recently reported in the news that were voicing difficulty with the medical marijuana law to the extent that, if you have Medicare and Medicaid pay patients, they can't administer medical marijuana without risking their federal funding. And if they're private pay healthcare facilities, this one healthcare facility that was in the article said that their banks told them that if they dispensed medical marijuana to a patient, then the bank was going to basically shut their account down because banks are federally insured and they're not going to do business with people that are involved in illegal activity under federal law. And currently, marijuana is still illegal under federal law, regardless of what is happening in the state of Ohio. Ooh, good question. Do these patient registry cards expire? That is a good question. I do not know the answer to that, but I can get back to you on that. If anyone has any substantive questions that they want to ask me that I did not address in this presentation, feel free to email them to me. Hope everybody enjoyed the webinar. Take care, everybody.